Everyone, I'd like to welcome you to the March 17th St. Patrick's Day session of the Calaveras County Board of Supervisors. Would you all rise and join me in the pledge? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, under announcements this morning, I'd like to announce that we had a closed session last week pursuant to Government Code Section 54956.9B1. This was a conference with legal counsel regarding anticipated litigation and significant exposure to litigation. We had one case to discuss, and we have nothing to report from that session. For those of you who might be spending the whole day with us, we have an agenda item number 11 that may seem a little convoluted, but we have to convene ourselves as the Air Pollution Control District for the first portion of that item, and then we'll be wearing our other hat. Maybe we might even wear a St. Patrick's hat at some point this morning. Okay, I would like to turn your attention to the consent agenda. These consent items are expected to be routine and non-controversial. They'll be acted upon by the board without discussion. Any board member, staff, or interested party can remove an item from the consent agenda, and we'll discuss it in detail. So do I hear any members of the board wishing to remove an item? Any members of the audience? I would like to remove item number 6 just for a brief acknowledgement to that the Calaveras County Arts Council. So do we have a motion on the other 5?
So moved. Second.
Okay, moved and seconded to approve items 1 through 5 on the consent calendar. All in favor say aye.
Aye.
Aye. And opposed? We have 5-0 for the approval of the items 1 through 5. Now, on item number 6, I have pulled this because this is a resolution designating the Calaveras County Arts Council as the official county arts agency and the state local partner to receive funds from the state or federal grants. Mary Jane Ginocchio is here in the audience this morning, and I wanted to introduce Mary Jane to all of you in the audience and at home watching TV. This is quite an unusual person. She's sort of the face of arts and theater and all those sorts of things for Calaveras County. I'm very pleased to know Mary Jane, and I wanted to acknowledge her efforts in the county along with her co-chair Penny West. Penny's not with us this morning, but I personally appreciate your efforts, Mary Jane. My wife and I take advantage of, as you know, many of your summer concerts and your Ovation series, and you just do absolutely wonderful things for this county. Thank you very much.
Thank you. Well, there's very little for me to say, Russ. I appreciate the introduction and commenting on the things that we do. And I'm here before you for the request and approval of the resolution that we are named the official Arts Council of Calaveras County. We apply for grants under this acknowledgement with the state as well as federal governments, and we're applying for a new state and local partnership grant of $15,000, and that allows us to have some operational funds available. So when we cup for money and we ask for memberships, that money can go back into our programs rather than operational costs. So that's why I'm here before you to ask you to approve the resolution, and then we can move forward on a grant that is due on March 25th. Now, a part of this, too, I also want to publicly thank the Board of Supervisors, the county government, for allowing us to have the in-kind rent at the Arts Council, 22 North Main Street. It's a historic building. It brings people in on their own since it's next to the Historical Society, but we benefit also from your generosity by allowing us to have the gallery and our offices in that building. So thank you very much.
You're welcome.
So as I stand here before you, I ask you to approve positively the recognition that the Arts Council is the Arts Council of Calaveras County, and it allows us to move forward in providing all of the events that are coming up. I'll mention the music in the parks. It starts June 17th, so get ready for that. And please come to the gallery for the high school art show. And if you have any questions, I'm happy to answer them.
Anyone wishing to ask Mary Jane a question?
You're filling some big shoes, but you've got all the stuff to do that with great distinction, and I'm delighted to see you step up into this position.
Yeah, thank you very much.
Okay, anybody from the audience wishing to comment on this? Okay, if not, Chair entertains a motion.
So moved.
Second.
Okay, moved and seconded to approve the resolution. All in favor say aye.
Aye.
Opposed? We have 5 ayes and no noes, so congratulations, Mary Jane. Okay, now we have a little bit of a difficulty here this morning. We have what might be a lengthy hearing that is scheduled ahead of the normal, usual, and customary public comments that are scheduled at 9:10. I would like to use the chair's discretion here a little bit, or consider it, but could I see a show of hands of people who have something that they wish to talk about under the items not on the agenda? Okay, 1, 2, 3, 4, 5, 6, about 6. Okay, now if I were to give each and every one of you, let me see a show of hands of the people who think you may take your entire 5 minutes. Okay. All right, well, I personally think that it warrants taking these people, Mr. CAO, I know that we shifted these things around to achieve a particular objective, but I think that we can get through both and take them.
The board has the power to work its will with respect to the agenda and its order, so whatever you choose to do.
Okay, thank you very much. We are at the designated time, so I would like to ask for items not on the agenda this morning. And the reason for that is that I think that I want to make certain that this second hearing, or the SEIU matter, it's conceivable that it may take a fair amount of time. So in respect for the people who are here that have taken time off work to come here, I don't want to force them to sit around and wait for that discussion to conclude before they make their comments for things that are not on the agenda. So please come forward and introduce yourselves and keep your comments briefly, or brief if you would, please.
Good morning, Mr. Chairman, members of the board. My name is Darrell Rusk. I live at 101 Melcher Lane in Burson, Valley Springs mailing address. My phone number is 772-0225. I attended a meeting last evening at Sutter Creek, or in Sutter Creek, at the Amador Water Agency's headquarters, where they were talking about the possible expansion of Pardee Lake. There were probably 50 or 60 people there. I would estimate that if there were 60, 59 spoke against it. One of the people who spoke extremely well, and I believe eloquently, on the subject was someone you all may know, and that was Steve Walensky. Okay, you don't have to admit knowing. But I thought he did a great job, not just on the subject per se, but he also spoke very strongly on the process of having public meetings in Calaveras County and showing a tad more respect on the part of East Bay Mud for Calaveras County rights. I also spoke, but only briefly, because their presentation never mentioned anyone else's water rights upriver. For instance, Calaveras County's water rights, Amador County's water rights, Alpine County's water rights. They never mentioned those things. I guess they weren't important. But anyway, I wanted to compliment Steve Walensky on that issue, and I wanted to make sure that was done in public. Thank you.
Thanks. Darrell's too modest. He spoke with great articulation and received thunderous applause.
3 of us.
Wow.
We're trying to speed the process here.
That only makes you 3.
Chairman O'Thomas,
Thomas,
Supervisor
yeah.
O'Tryon, Supervisor O'Walinsky, Supervisor O'Toffenelli, and Supervisor O'Callaway.
Callaway is Irish without the...
Okay.
Quite a cultural event here, apparently.
For his President Obama.
Couldn't make it.
No.
Top of the morning to you. My name's Jim Kavanaugh. I'm here with Donna O'Shantz and Zerl McDaniel. On Wednesday, April 1st, 2009, at 6:30 p.m., the Calaveras Council of Governments Board of Directors will have a public hearing in this chamber for the San Andreas Mobility Plan. The purpose of the San Andreas Mobility Plan, formerly known as the San Andreas Rural Livable Mobility Plan, is to provide a balanced circulation system for the San Andreas community, especially along St. Charles Street, State Route 49. We are here today to ask you that you attend this meeting. Supervisors Tryon and Callaway, we understand that you will most likely attend this meeting in your capacity as board members for the Calaveras Council of Governments. Supervisor Toffenelli, we ask that you will attend this meeting as a representative for the San Andreas community. And Chairman Thomas and Supervisor Walensky, we ask that you attend this meeting as well. We have provided CDs of the mobility plan for each of you so that you can familiarize yourself with the plan. For the over 2,000 children who come regularly to the San Andreas community for their education, for the approximately 2,000 people who are employed in the San Andreas community for over 12,000 vehicle trips to the San Andreas community on a daily basis, and most importantly for the approximately 2,600 people who call San Andreas community home, the San Andreas Mobility Plan is a tremendous opportunity to attain the highest level of circulation safety within the San Andreas community, to create an aesthetic which more fully promotes the historical, commercial, and rural opportunities, rural beauty of the San Andreas community, to provide more pedestrian bicycle opportunities for the San Andreas community, and to improve the overall health of all residents within the San Andreas community. We are not here to present to the board a plan that will place further stress on an already overburdened county budget. The San Andreas Mobility Plan is a long-term project for the San Andreas community. To implement the plan, the San Andreas community is committed to pursue available funding sources at the federal, state, and local level. The community will aggressively prospect for available grant funding from governmental agencies as well as the private sector. The San Andreas Mobility Plan would be able to use funds collected as part of the RIM fees, the establishment of San Andreas as a benefit basin, and any other appropriate development fees. As stated previously, we are not asking the board for any additional funding for the implementation of the mobility plan. The community is committed to use available funding sources for the implementation of this plan. We are sure that each one of you wants what is best for the various communities in which you live. Supervisor Tryon, Angels Camp, Supervisor Walensky, Glencoe, Supervisor Toffenelli. We weren't sure, Gary, Supervisor. Valley Springs, is that correct? Is that Valley Springs? But I mean, as far as your residence, was it Valley Springs?
Well, it's actually Burson.
Okay, Burson, that's what we want to put it in there. Supervisor Callaway, Avery, and Chairman Thomas Copperopoulos. The San Andreas community also wants to become the best that it can be. We ask that you familiarize yourself with the San Andreas Rural Livable Mobility Plan. If you have any questions, comments, or concerns about the mobility plan, we are more than happy to meet with you either as individuals or as a group. Thank you very much for your time and consideration. Anything that you can do to make the San Andreas Rural Livable Mobility Plan a reality will be greatly appreciated by us and by the San Andreas community. Thank you.
Thank you very much.
Before you step away, that was April, what was the date of that?
April 1st, 6:30 in the chamber here.
Okay, thank you.
Thank you very much.
I will attend.
Okay, thanks.
Anyone else?
Good morning. Good morning. My name is Rosemary Wilson, and I'm here in part to thank you for appointing me on the Area 12 Agency on Aging Advisory Council, and also to inform you and the public of a series of meetings that have been scheduled for the to take place at the office of Area 12 Agency on Aging on Standard Road in Sonora. These, a total of 6 presentations are going to be lunch presentations with lunch provided, and they are going to be addressing caregiver issues with professional people speaking on subjects of which they are knowledgeable. They start on the 26th of March with a program on Alzheimer's. They continue April 9th, doctor's visits. The 23rd of April, an attorney will speak on durable powers of attorney, wills and trusts. There's going to be another one on the 14th of May. I'm afraid I didn't get the topic for that one. Drayle is going to be speaking on the 28th of May on adaptive equipment, followed up by someone talking on the emotional aspects of placing elderly seniors into assisted living or other facilities. And that's going to be on June the 11th. And the agency is requesting that the people interested pre-register, and that can be done by calling 1-800-510-2020 or the local number 532-6272. I believe that's it. There's going to be a good free lunch. The seating is limited, so please call ahead and let other people in your community know about the upcoming events. Thank you.
Thank you, Rosemary. Good morning, Mr. Harrington.
Good morning, Brett Harrington, Interim Community Development Director. I was going to say some Irish-themed comment to start, but I can't top those earlier speakers, so let it go. I'm here for one quick item. As of yesterday, Thursday is the Planning Commission hearing on Trinitas. We hope and believe the Planning Commission will take some kind of action on that. So we've been looking ahead for some time for an appropriate date to schedule the hearing when it comes to you. And it's something I want to get to you while I'm still here and have some degree of control over the time. And we felt fine yesterday morning because we had reserved the 21st of April, and then we found out that Russ was not going to be here on that date, and that's our fault. We should have known that. So after some scrambling, because a lot of it has to do with the availability of the town hall, we're looking at April 14th for that particular hearing. And I'm standing here because I want to make sure, rather than get to a series of calls, I need to lock the room down. Is anybody not going to be here on the 14th? Okay. Then I'm going to go ahead and book the hall for that. I should tell you that one of the reasons we picked the 21st is Janice and I both have a problem on the 14th beginning at 5 o'clock. We have commitments to other spots. So that would seem like that shouldn't be a problem, but given that the Planning Commission went past 5 o'clock on their hearing, we just want to let you know that up front, and we'll figure out how to deal with it. So I will go ahead to the 14th and book the town hall.
Well, Brent, maybe a suggestion would be is to start it at 1 rather than 1:30.
Oh, no, we're starting you at 9.
Oh, okay. That's the day. Oh, okay.
I need to get
my helpful hint.
Well, when we had it set up for the 21st, it was basically going to be the only thing on. Now that we're moving, we may have to do some juggling. You may have something else. I don't know what else other departments might turn in, but the idea will be, given that the Planning Commission went from 10 till after 5 with a half-hour break for lunch, and therefore spent 10 to 5 minus a half hour and a couple of short breaks on their hearing, and one would expect many of the same speakers will speak again. I think you'll be camping out all day, is my prediction.
That might be up to the chairman to sort of consolidate people that want to make comments on particular subjects.
We were thinking one of those roadside signs that say stop.
Yeah,
set it up at the appropriate
yeah,
time.
well, we can handle that.
We'll talk about that as we get.
But on your having to get out of there for a time certain thing, that you have to leave prior to 5 o'clock so you can get someplace at 5, or what's?
I will need to leave about 5 to 5, and Janice, I'm not exactly sure, but it's both commitments we had long before this.
Right, we can work with that.
We'll figure out how to do it. Thank you.
Anybody else wishing to speak on item not on the agenda? Darrell, you have one more bite at the apple this morning.
I'm sorry, but there was an issue that I raised at the last Planning Commission meeting that was held in that town hall. I've got to tell you, it is not disability accessible. And there are more than one person who are wheelchair-bound, and at the last hearing, they weren't able to get to the building. It does present a difficulty, and if it's possible, possibly not on this particular date, but in the future, it would be very helpful for those who are disabled to have a handicapped accessible location.
Is this a matter of a ramp at the entryway?
There's no ramp there.
Right, but if there were, would that
That would help.
accommodate?
And there's also, the nearest handicap parking is downhill.
Okay, let me suggest as a result of this that we ask our Public Works Department whether a temporary ramp can be installed for the purpose of this meeting, and that we mark the front of the area right at the entrance as a handicap parking and drop-off spot. I think that's the least we can do under the circumstances, and that we should not create barriers to participation.
That would be much appreciated by several people in the community. Thank you very much. And by the way, I thought I still had 113 seconds, but
All right. Thanks, Darrell. Okay, one last chance, then we're going to launch into this SEIU matter. All right, that concludes the comments not on the agenda. So we have a discussion of possible action regarding a petition for unit modification / severance appeal hearing based on a request by SEIU, and the board will take action on this thing. And Supervisor Walensky has requested just a moment to make a comment at the onset here.
Yes, thank you, Mr. Chair. As many people know, I spent 32 years of my life before becoming a member of this supervisor's body in the labor movement. Started with the United Farm Workers, went to Sugar Workers, IBT, and the last 23 years before coming here, I spent with the Service Employees Union, both with locals and the international. I am pension eligible through SEIU, and I also get my medical benefits as a retiree from that organization. I've reviewed, some people have suggested that those facts would indicate that I should recuse myself from this hearing. A careful review of fair political practices, commission rules and regs, consultation with county attorney and as well other attorneys indicate that there's no legal requirement for recusal under the circumstance, and therefore I will not recuse myself. However, I'd like to add a couple of comments. First, it was my hope upon being elected with that background that some of the things that I've been involved in, including 70 unit determination hearings, my guess is that's more than many of the people in both staff and sitting on this board, before the National Labor Relations Board, under Myers-Milius-Brown, and working with both law enforcement, sworn and non-sworn. I had originally, in my naivete, thought that that background would actually lend some breadth and depth to the kinds of deliberations that we have here. I know that a labor background is only one part of an equation, but I've always felt that it was not incompatible with roles and responsibilities in a management role, that actually trying to reconcile differences is the whole purpose of having labor relations in the first place. My experience in the 18 counties of California and the several states that I did this work in, I had thought would lend some perspective. That has not been greeted by some of my colleagues with the same spirit that I had hoped for. I have been very consistent in the 32 years that I did this work in hoping for moments like this to be adjudicated by neutral third parties. I find it very difficult in this situation, both with my background, but also knowing that virtually everybody up here has either been endorsed or opposed by one or another or both of these organizations, that this does not create the kinds of laboratory conditions that I find conducive to good policy results. So it is for that reason, not recusal, that I will leave this meeting and not participate. I would ask that the chair record my vote as absent. I would ask that the clerk of the board come back to the administrative offices when this is over and recall me to my board duties. And I would ask that that people pay very careful attention to whatever the legal framework presented to you might be. And thank you for hearing me out.
Thank you very much, Steve. Okay, I have a question for legal counsel. We have no staff report on this, so I don't know what we're being, what the specifics of what we're being asked to do. But if this board makes some sort of a determination, is it appealable by any of the parties to subsequent decision makers, or could it conceivably end up with an arbitrator anyway?
Well, from a Brown Act point of view, if there are no documents, the only requirement is if you have documents, they have to be made available to the public. So we don't have a Brown Act issue. I would ask David to comment on the other part of your question.
If I may, there's no documents in front of you because this is a hearing. And so each side has to put on their evidence.
Okay.
Giving you evidence before would disadvantage the other party.
Okay.
And as far as appeals go, if the board chooses to make the decision itself, whether the board makes the decision itself here or whether the board sends it out to a neutral arbitrator, which it may do, the other side agrees. Both of those decisions are final. They're final and binding, and the only recourse would be for the other party to bring a writ mandate in court.
Okay, any other board members have any question? Okay, proceed.
Okay. Good morning. Francine Osborne, Director of Human Resources and Risk Management. Today, the board will be hearing SEIU's appeal of my November 17, 2007 letter in which I approved the Calaveras County Public Safety Employees Association and their ability to conduct an election. The issue before the board today is whether or not my decision was consistent with the county's employer-employee relations resolution. It's my recommendation that the board allow SEIU to make their presentation first, since it is their appeal. Following the conclusion of their presentation, I will make a presentation in which I will explain my decision on this matter. Finally, if the board so chooses, they may allow comments from anyone who may wish to speak from the proposed new unit and also anyone from the existing unit. And with that, I'm going to go ahead, unless there's any objections, and turn it over to SEIU so they can begin their presentation.
Thank you for hearing us today. My name is Matt Gauger. I'm an attorney with a law firm called Weinberg, Roger, and Rosenfeld, and I'm SEIU's lawyer. It's a pleasure. Thank you for your time, and I'll try to make this fairly straightforward for you.
Excuse me, Matt, before you launch in, your last name is what?
Oh, I'm sorry. It's Matt Gauger, G-A-U-G-E-R, and I'll give the clerk my card when I wrap my car and get it after I'm done. I'll be very straightforward. The question is whether the bargaining unit that Ms. Osborne carved out of the existing bargaining unit complies with your local ordinance, and whether it complies with the state law, the Myers-Milius-Brown Act, which is the state labor law that applies to counties. The union, it does not, and there's 7 reasons it does not. And we're going to give you a written presentation, but I'm going to outline the reasons briefly for you so you have something to think about when you look at the documents. As an overview, Mr. Sirius told you that your decision is final and binding. That's not the case. Your decision can be reviewed by the Public Employment Relations Board. If your decision has any errors in it that violate either your local ordinance or the MMBA.
Could you please speak English, MMBA?
Okay, I'm sorry. The Myers-Milius-Brown Act.
Thank you.
And that's a great question, because in California in particular, but in the United States in general, our labor law is a sandwich. It's layer after layer after layer. We look back at what the people did 20, 30 years ago and say, boy, we wouldn't have done it that way, and we change it. So we get layers. So MMBA, Myers-Milius-Brown Act, was first passed in California in 1968. In 2000, the legislature and governor said the courts no longer decide disputes under the Myers-Milius-Brown Act, as they had for 30-odd years. The Public Employment Relations Board does, which is why any dispute over your determination goes to the Public Employment Relations Board. Generally speaking, under virtually every other labor law regime, an expert administrative law judge hears cases like this. Except in California, for cities and counties, we have an idea of local rule, which is the people who elected you entrust you to hear it. So you have a choice. Unlike the state, unlike private employers, they have to go to an administrative law judge. You have a choice. Either you can hear it, or you can hire a mutually chosen arbitrator for a final and binding decision. Under your local ordinance, if you choose an arbitrator to hear this argument and hear all these facts, then his or her decision is in fact final and binding. Neither side could appeal it to MMBA. Why? Because that's what your statute says, your local ordinance says, and in fact the union would agree to that just so that the dispute could end there. The union would agree that it would not appeal any decision of a mutually decided arbitrator. So what I'm asking you, the union is asking you to do 2 things. First, to reject Ms. Osborne's carve-out of the unit for the 7 reasons I give you. Or in the alternative, the union is asking you to direct labor relations to operate under that portion of the local ordinance to choose along with the union, choose a mutually selected arbitrator to issue a ruling, a final and binding ruling. So with that, there are 7 reasons why the decision that Ms. Osborne made, the ruling she made, is not appropriate and violates both your local ordinance and the Myers-Milius-Brown Act. The first reason is because the local ordinance in Section 9 specifically says that the bargaining unit should be the broadest feasible unit. What does that mean? That means a unit that works. Is this a bargaining unit that has worked for you for what we can tell, about 34 years? The answer is yes. You have not had labor unrest, you have not had significant strikes, and you've been able to achieve collective bargaining agreements with your employees for that entire time. It's a broad unit. Most counties have broad units like this, and it's obviously feasible because it works. There's another standard in there, which is do the workers have a community of interest? Do they share a community of interest? What does that mean? Well, are there some basic interests that all your employees share? And the union would argue yes. Over the 32 years that it's existed, the bargaining unit has existed, the things they share are the basic things that all employees look for: wages, terms, and other conditions of employment. Sure, you have different work rules for somebody who is a carpenter versus a cook in the jail. Absolutely. But all employers are like that. If everybody who had different work rules had a separate collective bargaining unit, you'd end up like San Francisco, which has 40 bargaining units, which is a nightmare for all concerned, in my humble opinion. The second reason, that's Section 9 of your local ordinance. The second reason is the bargaining unit that Ms. Osborne proposes has peace officers and non-peace officers in the same bargaining unit. Now, the union acknowledges that the current unit also has that, but the current unit existed prior to the current law. And the way the current law works is prior non-conforming units can continue to exist unless there is a problem. If there is a problem, you can carve out peace officers. Both Section 9 of your agreement or your local ordinance and the Myers-Millis-Brown Act say that. Now, Ms. Osborne has said that this unit is comprised of, quote, people who are safety professionals in nature. That's not a term of art. Both statutes, both your local ordinance and the MMBA, use the same term of art: peace officers. If they get carved out, they get their own unit. The people who are peace officers in this bargaining unit are limited. There's only 5 groups of them. They're the correctional officers, the correctional sergeant, the deputy probation officers, 1, 2s, and 3s. Everybody else in the carved-out unit, cooks, service techs, records managers, animal control officers, are not peace officers. And I'm going to give you this written argument at the end of the presentations, but we've included for you the job descriptions that you have for each of these workers, and you will be able to see that the folks I just mentioned are not peace officers, the correctional officers and the probationary officers are. That was the second reason. The third reason is similar, only it deals with professionals. Again, you have a big non-conforming unit that's working for you, and here you've got a few professionals that you're throwing into a unit with non-professionals. That violates both your local ordinance, Section 9, as well as Article 1, Section 3, Sub F, lawyers like all that stuff, as well as MMBA. Okay, it's the same problem. Professionals are different. If they get carved out, they get to go by themselves. They don't go with other folks. That's a problem with Ms. Osborne's unit. Here, the professionals in the carved-out unit are deputy district attorneys and paralegals, arguably paralegals. It is unlikely that any union that represented this proposed unit would continue to say that cooks and sheriff's techs are professionals. Why? Because under the Fair Labor Standards Act, professionals do not get paid overtime. You are not obligated to pay professionals overtime. You can work them until they fall down dead, literally, without violating wage and hour law. You violate OSHA because it's unsafe, but you can work them without paying them overtime. No union worth its salt would ever let somebody who is a cook be treated in that manner. 5, it violates specifically Section 9B of your, 4. It violates 9B of your local ordinance. 9B is really interesting. It's a reference to the radical union organizers in the 1930s. In 1935, when the original Wagner Act was passed, the bargaining unit description is not what we have here, not this kind of community of interest, you know, these like people, are they professionals, are they peace officers? That didn't exist. It was called the extent of organization. Unions would go in and sign folks up and say, okay, we represent the cook, the lawyer, the police officer, and the mechanic, and no one else. Well, they don't really have a community of interest without everybody else being there. And those bargaining units existed from 1935 until 1947, when the Congress, over President Truman's veto, adopted Taft-Hartley, which is where this language we're talking about comes from. Taft-Hartley is the reform or the change of the radical labor law that personally I liked, but the majority decided no, that is not going to work in the long term for the United States. This unit that you see here is an extent of organization unit. It's some of the folks who have something to do with law enforcement, not all of them, but the ones who apparently are interested in joining this new organization. It directly violates your local ordinance, and Perb, I think, would say so and have some fun with the history. Fifth, there's been a failure to provide written proof of a third support. And the reason for this is Ms. Osborne relied on an August 15th letter from the new organization's attorney. Their attorney is named Paul Goyer, who's a good attorney and actually not a bad guy. I know him. But what Mr. Goyer's clients did, I think they misled him, or they didn't mislead him, they made a mistake. The numbers of folks in the job classifications that the new organization claims are not really the numbers of folks who are employed in those classifications. And the written documents that we're going to provide you lay that out. As an example, it says there are 10 correctional corporals and only 1 correctional officer. That's just simply not accurate. And so for that reason, the petition is flawed and should not have been accepted. The next reason is the petition was not filed during an open period, another term of art. What is an open period? Your local ordinance says that a union can demand to be recognized or a part of the unit be carved out only during a certain window period. That period, that open period, is between 100 days and 90 days prior to the expiration of a collective bargaining agreement. The document on which I misspoke a moment ago when I said the 15th, the document that Ms. Osborne relied on was dated, the petition she relied on was dated the 29th of August 2007, which would fall into the open period because the collective bargaining agreement that year expired on November 30th, 2007. However, in the meat of the document, it says that someone from Mr. Goyer's office talked to Ms. Osborne on the 30th of August. And she told them, no, your 15th petition wasn't right. The reason it wasn't right is because it was a decertification petition. That's not appropriate. A unit modification petition is appropriate, and you need to file a unit modification petition. The letter says that conversation happened between Osborne and a man named Luciano Beltran on the 30th of August. They then filed their unit modification petition. The unit modification petition is dated the 29th of August, but that's obviously impossible because the conversation happened on the 30th. Therefore, the unit mod petition had to have been filed after the 30th. If it was filed after the 30th, it was untimely. Thing 7. The local, Ms. Osborne and Mr. Sirius have violated the union's due process rights and violated MMBA in the process. I requested, and the papers we provide you will indicate such, I requested a continuance of this hearing because I needed more time to prepare, because we didn't get notice of this hearing until 10 days ago, which is appropriate under the Brown Act. However, I was gone all last week, and it was very difficult to prepare. And quite frankly, I wanted to provide a more detailed presentation to you. I'm not sure if you would have wanted one, but I wanted to provide one. So I asked for a continuance. Mr. Sirius told one of my colleagues that you had said no to the continuance. Yesterday he told me that you in fact did not say no. You in fact were not nobody requested a continuance to you. So that I think hurts the union to not be able to provide a more detailed presentation. Second, the union requested release time for one of its leaders, Brian Galicia, and that request was made mid last week when the union learned on last Wednesday, when the union learned that there would be no continuance. The release time for Mr. Galicia to help prepare this presentation was not granted until yesterday at about 4 o'clock in the afternoon. Now, Mr. Galicia, Mr. Fauch, and their colleagues worked really hard last night to help me prepare this presentation and help me prepare the documents that we're going to present to you. But under MMBA, it is required that a reasonable request for time be granted. And it was unreasonable in the union's view that it wasn't granted until 4 o'clock yesterday afternoon. To sum up, these are interesting questions to me because this is my life. This is what I do. Like Mr. Walensky, I've spent my life in the labor movement. I too started with the farm workers union. However, I can appreciate that this may not be all that interesting to most people, particularly the historic reasons for the way bargaining units work. For that reason, it is, in my view, prudent for you to either reject the petition, or two, if you think the petition has merit, direct your staff to work with SEIU to choose an arbitrator for a final and binding decision, so this will then be over. We wouldn't be able to appeal from that. We would present the case very similar in outline to what I presented to you, to the arbitrator. The arbitrator would decide the case in a certain period of time, and either the unit would be carved up or it would not be carved up, and that would be the end of it. I don't know if you have any questions, but we will present our documents to you as soon as they're photocopied, quite frankly. But if you have any questions, I'd be happy to try to help you.
Anybody have any questions of Mr. Garner?
Yes. I'm not on the last part of what you're talking. Are you asking for another continuance?
No, I'm not.
Okay, because you addressed it. You said the postponement, et cetera, and I felt like you were asking for a continuance because you were on vacation or whatever. So you're not asking for that?
We did ask for a continuance. The continuance was denied at a time that the continuance would have been useful. But since we had to do what we had to do last night, and since we had to rearrange ourselves to be here, I'm not asking for the continuance, but I'm also not waiving the argument that the failure to provide a reasonable continuance was a violation of the union's due process rights.
I think the gentleman needs to elaborate on that. No one in my office has the authority to continue a board matter, so if they want a continuance, that should be so stated. If not, then I think it has to be moot. We don't take the position that we grant or not grant continuance as a matter. That's up to the board.
I think counsel is absolutely right. Certainly county counsel no lawyer should ever grant a continuance of import without talking to his or her client first. The union's complaint is simply that nobody inquired of you, and that is a problem. The request for continuance was made immediately upon notice. I know you had a meeting last week. You could have been, without violating the Brown Act or having a serial meeting problem, the inquiry could have been made of you, and it was not.
And it can be made now. That's my point. I think if he wants a continuance, that request should be made.
Because that's what I thought I heard him say.
I did not say that. I said that the union's rights were violated because the continuance was not granted. And in addition, lawyers in Northern California, certainly in the valley and in the foothills, when we work with each other, there's much more of a collegial culture than there is in San Francisco, Los Angeles, or San Diego. And part of the reason is it's a small town. We all get to see each other now and then. And when one asks for continuance, generally the other side tries to grant it. Here there was no effort whatsoever. Now, whether or not the collegial nature of lawyers in the rural parts of California are part of MMDA is an argument that would be a novel one. But it is certainly the practice that when a lawyer asks another lawyer for continuance, the person hearing the continuance goes to talk to his or her client. That didn't happen, and because of that, it's the union's position that the failure to even inquire of you was a violation of the union's due process rights. That's the union's argument on that.
And the other is, if we reject the petition, or if we think it has merit, you would like us to have staff negotiate or discuss whatever adjective you wish to use with SEIU to choose an arbitrator. Why would the board has the authority to make the decision? Why should we, I mean, what's the advantage of going to an arbitrator versus having this body make the decision?
That's a good question. Two things I think I need to say to that. First, if you reject the petition, of course I don't think you should go to an arbitrator because we win and it's over then. The county cannot appeal that decision. But if you accept the petition, then the union does have the opportunity to appeal that decision to PERB. And given the arguments I made, I think that appeal would not only be likely to happen, but I think that especially given the fact that you've got peace officers, thank you, you've got peace officers and non-peace officers in the same unit, I think it's highly likely that PERB would reject the unit. Now, why direct staff to trigger that portion of the local ordinance that says that there can be a mutually selected arbitrator who will give a final and binding decision? The reason for that is speed and cost. I've told you that if the staff does that, the union will not appeal, will agree not to appeal the arbitrator's decision to PERB. The cost of doing the PERB appeal is not insignificant from you, even if you use your own staff to do it, because it's staff time. Mr. Jones will explain, has probably explained that to you on more than one occasion. The other reason for you to choose an arbitrator or direct staff to mutually choose an arbitrator with the union is you get someone who is an expert in this area. And, the judges all say, when you say to a judge, with all due respect, Your Honor, what the judge really hears is, Your Honor, you're dumb. But that's not what I'm saying to you. What I'm saying to you is this is 75 years of history that you're going to try to figure out in 5 minutes. And it's not really fair to you. And it's also not fair to the employees, some of whom have a legitimate beef. The peace officers want out of this unit, and they may have some merit there. But this unit that is described will not fly with PERB. And so their need, their want, which may or may not be legitimate, but certainly legally supportable, is not going to be served, because we have to appeal the whole thing. And PERB will take a year to do it. I mean, we've been to PERB once. We filed a board charge. They issued a complaint. Parties settled it so we could come and talk to you, basically. And that took almost a year. This case, deciding on the substance, will take PERB more than a year. Now, is the arbitrator more likely to get it right on the history and on the use of the terms of art? Probably. On what your workers do on a day-to-day basis? The arbitrator would probably be less familiar with that than you are, but the parties would have to make him or her familiar with that. The question of who is a peace officer and who is not, that is a decision that is a technical legal one that's based on your job descriptions. You and an arbitrator would probably get both the same answer. You'd look at the job description and say, okay, this person's a peace officer, this is not, but the arbitrator is used to doing that. The other legitimate interest you have is, well, we want to control it. What I'm telling you may sound counterintuitive, but it's true. You get more, not less, control out of an arbitrator. Because if you make a decision that puts peace officers in with non-peace officers, or professionals in with non-peace officers, then we're all at the mercy of PERB. If you, your staff, and the union's staff, me, choose an arbitrator, we have a lot more control over the outcome than we do at PERB. So that, I hope that answered your concerns. PERB, the Public Employment Relations Board. No acronyms. Any other questions?
You mentioned Mr. Goyer.
Yeah.
Is Mr. Goyer here?
I don't know. I don't know.
I'm the General Beltran. Oh,
Okay. Thank you.
Mr. Beltran is the person I mentioned earlier who had the correspondence exchange with Ms. Osborne.
Okay. Any other questions of Mr. Gauger? Okay, I think that concludes step number one.
Okay, thank you very much. I'll be in the audience.
Thank you.
All right, at this time, I'm going to address my role and explain how I made my decision in this matter. I'm not going to address any legal issues, as any legal issues regarding this matter were forwarded to County Counsel's office, and David Sirius, after I do my presentation, will come forward and address any legal issues before the board that were brought before you. I think the first thing is the documents that I handed you are my letter of the determination, and the second letter reaffirming that determination. The larger document is actually the county's employer-employee relations resolution. And in that resolution, the Director of Human Resources is designated as the Employee Resolutions Officer. That role means that any group that follows those rules, then I have certain guidelines I must follow. And in this instance, I did receive a unit modification on August 15th of 2007. I utilized Section 9 to base my decision. There are two criteria under that section that I used. One is the efficient operations of the county and its compatibility with the primary responsibility of the county, its employees, to effectively and economically serve the public. The second criteria was providing the respective employees with effective representation based on recognized community of interest considerations. Finally, the EER, which is the Employee-Employer Relations Resolution, states, these policy objectives require that the appropriate unit shall be the broadest feasible grouping of positions that share an identifiable community of interest. The process began by the unit modification, and then under the EER, I held a meeting with all interested parties. That meeting is basically so that each party can identify factors that I should consider before I make my determination. SEIU did not attend that meeting. The only factors that were presented to me at the time were from the unit that was proposing to be formed. I took that into consideration. I wrote my disposition, and I took a considerable amount of time weighing all of this, working with county counsel's office, and making that determination. And I issued my November 13th letter. The parties immediately went to mediation, and some of the issues that were brought before you are some of the items that were discussed. We were in the process of working together. The county was pretty much out of it. It was between the two proposed parties. A considerable time went by, homework was not done, and it was concluded that mediation was unsuccessful. Pursuant to that, I issued and reaffirmed my decision. The EER actually allows the group to appeal to the board, and that is what they are doing today. At this point, I still believe my decision is proper, and I strongly urge the board to deny the appeal and allow the unit to have an election and allow the employees to vote their choice for this new unit. And I'm going to have David come up and address all of the legal issues.
I'll be brief. In reverse order of the issues that were brought up by counsel for the appellant. Briefly, the continuance issue is really not an issue. Counsel's partner or colleague requested a continuance a few days, probably a week ago, a few days after this meeting was scheduled. And what I did is I told counsel that he was free to come to the meeting today and ask for the continuance, and the board would probably grant a continuance. So I don't think that that's an issue. The fact that they've made their presentation makes the whole issue moot. As far as the petition being untimely, that really is not an issue either, because the original petition was called a decertification, even though what they were trying to do was unit modification. So they just mislabeled it, and Ms. Osborne corrected that. As far as written proof of support, we've already been to PERB, and PERB agreed that there was majority support. As far as the extent of organization, I don't even know what that means. It's in the ordinance, and I don't even know what it means. But the fact is that it's only one factor of many that the board would take account of. If you read Section 9, that'll become clear. As far as the argument that there are professionals in the unit, that's not really an issue either. What the EER says is that managers shouldn't be in units with rank and file, basically, and that's not the situation here. Then the issue of it being a mixed unit, peace officers and non-peace officers, that also was, we also went to PERB already over that, and PERB dismissed their complaint. And that's really all I have. We do have a representative from the new proposed unit here. You may want to hear from them.
Dave, I have a question.
Yes.
I'm looking at the MOU. I'm looking at section 12 under appeals.
Yes.
And it says that the appeal, it says a request to submit the matter to mediation by the State Mediation and Conciliation Service, or may, in lieu of thereafter, appeal such determination to the County Board of Supervisors for final decision.
I'm sorry, you're at section 12?
Mm-hmm. So if we make a decision here today, Mr. Gagner said that they can appeal it. Yeah, I'm reading this MOU that says when it's appealed to us, it's a final decision.
Yes, the board's decision is final, and if you send it to an arbitrator, their decision is final. They're both final.
So you're saying they're both final?
They're both
There's
final.
no appeal after today?
Well, as you know in law, you can appeal anything. They could go to court, they could go to PERB, but higher authorities tend not to try to interfere with discretion of the board, or the arbitrator, for that matter.
David, I just want to, could you excuse me a moment, please? Follow up on what Gary asked. If it is appealed, what happens to the situation? I mean, if this says that our decision's final, or an arbitrator, and we have that choice, and we are being asked that if we accept the petition, then work with SEIUs to choose an arbitrator, I thought I heard counsel say that if we make the decision, SEIU will appeal to PERB. And which I'm hearing you say, yes, they can do that if they want. Our code says that our decision's final. That was my understanding. It's our decision or an arbitrator. If they choose to, where does this put all this hanging?
I think what counsel said was that if you send it out to an arbitrator, they will accept the arbitrator's decision, and they won't do anything, and they won't appeal.
But if we make the decision,
then they're basically telling you that they're going to try to tie it up.
Unless it's in their favor. If it's in their favor, then
well, that's me. But so what? So I guess the latter is what I'm asking. What happens to this if they, to use your terms, tie it up? Does this just hang out there for another 2 months, 2 years?
Conceivably. I mean, they could go to PERB, and PERB could dismiss it right away. On the other hand, PERB is just like court. It's a crapshoot. So PERB might keep it for a year, or they might dismiss it in a week. We don't know. Just like any adjudicatory body.
Well, we've already gone there. And are we looking for another answer? I'm not clear why they would even want to go back. Because we, or both sides of the issue, have already been there.
I'm not sure that there's a question, Marina.
Okay, David, you said PERB agreed with the majority, so they dismissed the complaint. So if we make the decision...
I don't think he said that they dismissed the complaint. What he said was that on the issue of intermingling the professionals and non-professionals in the unit, that they said that was okay.
I think what you're asking me is if this decision, whether it's the arbitrator or us, whether
Correct.
or you, whether it's the fact that it says final doesn't mean that they can't try
I
to
understand that, okay.
exhaust more appeals.
Okay.
But again, we can't predict. Lawyers don't like to predict what appellate courts do because they do all kinds of things.
Okay, Mr. Sirius, on the issue specifically of the initial document that was filed was a decertification. I mean, if it said at the top of the page that this was a decertification request, and that was, as Mr. Gauger has suggested, that he made specifically the point that there was a timeliness factor here, and in many instances this board has to make a decision about whether something was filed before 5 o'clock on a particular day. That's the overriding thing that we have to think about. Now, it strikes me as being very peculiar that Ms. Osborne could simply strike out the term decertification at a later date and put the what is the other issue is the unit modification request. On her own initial, I'm struggling with the admissibility of that.
She didn't do that on her own, and I think Mr. Beltran could address that. But that was essentially just clerical error. It was just ministerial error. It was not legally significant. In our opinion, it was not legally significant.
Well, I'm wanting to hear if anybody else has a differing opinion.
My name is Luciano Beltran. I'm of Goyer and Associates. And I'll answer that question just real quickly here. We were contacted by Francine, and she told us that she had talked to county council. She felt that this was a modification, not a desert, so we submitted the papers in the open window period. Open shut, right during the open window period. That's what we did. I do not agree with appellant's counsel that they're saying that we had some type of conversation on the 30th regarding this issue and then we backdated it. That is not true. That's not what occurred.
Okay, thank you very much.
Now, could I go into some issues that were brought up by appellant's counsel here that I need to actually address? Since he went down memory lane, selected memory lane, I thought we could go down probably the last 2 years, because in July of 2007 is when this process started. July of 2007. The normal recognition petition type process takes probably about 4 months at the most. It's almost been 2 years. Not by our help. We've done everything in a timely manner. So, what happened was we submitted the petition and resubmitted the other one that was corrected. Francine granted the petition in November, so then it was appealed, and in the EERR, it says in there that the employee relations officer who... EER is your employee relations resolution. When I say EER, that's what I'm talking about. Each public agency has an EERR or an EERO. Anyway, so we went to mediation on January 17th, 2008. And we sat, it was at the water district there, we had everyone there, including the state mediator. And SEIU's representative requested that we could come back in 2 weeks because they wanted to go back and talk to all the employees who signed the petition to break away. So we said, like, we're trying to do our best to work this thing out, so we said, okay. So what happens on 14 days later, or the 31st of January, 30th, whatever day it was, they cancel out, they don't show up, and then they don't want to meet after that, apparently. So from January 31st all the way to April 14th, nothing's going on with this petition because SEIU is not meeting with us and mediating. They're the ones that appealed this process. So Francine contacts the mediator. Mediator says, well, since the other party is not going to come and mediate, I've got to have two mutual parties to agree to mediate. So she said mediation is terminated. As a result of that, Francine then said, well, it's terminated, so now she sends a letter to me and also SEIU and states that they can appeal this to the board at that time. That was April 14th. So, from April 14th to sometime, I think in October, there was, again, we were trying to get this thing to work out. If you look at the EERR that you have in the modification language, it doesn't say nothing about an election. But we agreed with the county to make this a lot better, or a lot, I would think, more safer or more democratic process, that we would agree to have an election. So we have the employees decide what they want to do. So we're going to go ahead and have this election, even though SEIU had not responded within 30 days to appeal this to you, the Board of Supervisors, on April 14th. They didn't, from April 14th to May 14th, there was no response from them. So at that time, they argued that whole point of the fact that, well, we got the letter a few days before the expiration date of that timeline, et cetera, et cetera. That's why we went to PERB. We went to PERB for that reason, because they were complaining they didn't meet, the county didn't meet that timeline because they sent the letter too late to them. That's why we're back here today, because of the April 14th timeline to May 14th of 2008. That's why we're here today. So let's go back to the election part of this. So we set up an election. We sat down and talked about what we were going to do in the election. We got a date. We sat with everyone, including mediation. The date was set, and then the day before the election, somebody from SEIU's office contacted the mediator, and that was Shirley Campbell at the time. She's retired since. And she's notified there's an issue regarding the peace officers that are in the bargaining unit, that they cannot belong to a bargaining unit that is run by non-sworn employees. Even though currently this unit right now has peace officers in it, and they're being managed by non-sworn employees. But they brought this issue up like the 11th hour, and Shirley Campbell felt that this may be an inappropriate election, so they stopped the election. So then we end up going to PERB on this whole issue about what all these issues regarding what's an appropriate unit, all these things that Mr. Gogger had talked about when they went to PERB. And with Mr. Sirius explaining that PERB said the issue with the peace officers, don't even worry about that. Let's just get everyone back to the Board of Supervisors and get this thing all done. So I'm still saying, let's have the election. Let's have the employees go in there and decide who they want to represent them. We still have the majority of the employees. I could have them all sign the petition today and have them give you the petition again with all the same signatures. So now let's go into what Mr. Gardner said about some of these things about the community of interest. The broadest feasible unit. Well, let's use an example. City Modesto has a very similar employer and employee relations ordinance to your EERR. The language is almost the same. They have a unit there, a bargaining unit, that has dispatchers, community service officers, technicians in it, separate from the normal miscellaneous unit. That occurred about 2 or 3 years ago. So that's 55 miles from here. So he's saying that that's not common. Well, 55 miles from here, I have a unit very similar to what we're trying to do here today. Now he says that, well, the peace officers are in this unit right now. It's okay because the law has been changed since then, et cetera, et cetera. Well, to be honest with you, and to Mr. Gogger, these peace officers at any time during the open window period can actually file a petition on their own under the law and carve themselves out of this unit that's going on right now, separate from what we're doing here during that open window period. And let's talk about the deputy DAs. They can also do the same thing under the professional employee language under state law. he talks about the fact that I put, I think, 10 corporals in there. There's not 10 corporals, whatever. Well, shame on me. I made a mistake. I guess his office does not make a mistake. If I went to his office and looked at 10 random documents, I'm sure I'm going to find a mistake there. Okay? That happens. We all know that. We're not perfect. And again, I just want to address the fact that that open window period we made on both those, on the first petition I filed and the second petition. I don't know what he's talking about, that I didn't make that second petition on the open window period. And regarding the continuance, my God, how long are we to go? 10 years on this? It's been almost 2 years on this here. You were elected to make a decision here on issues like this. You have the authority. Now, I'm not going to appeal this to PERB. I'm not going to appeal this to anybody. This is your final decision. If you decide you're not going to go this way, then that's it. That's where it's going to go. You're going to have a bunch of unhappy employees that are under this umbrella that they're under right now. All I got to say is that we, this firm, these employees are willing to have an election to get this thing resolved. That's what we want to do. And if SEIU wants to continue to stall this thing out and send it to PERB, send it to an arbitrator, it's not going to solve anything as far as the employees are concerned. That's all I have.
Any questions for Mr. Beltran?
Yeah, I don't know if this is a fair question, and if not, I expect Ms. Osborne to tell me, but why do they want to carve out?
They're unhappy with their representation, to be honest with you. And they can come up here and explain some of their reasons why. That's why they're here.
Okay. Thank you. It's just... I have another technical question. I don't know, Francine, if you... I think, I'm not sure if it was in your letter or no, maybe it was, excuse me, can I see the letter I gave you from the SEIU attorney?
Yeah.
Thank you.
The one I didn't have.
Yeah. Under Section 12 of the Employee Relations Board Ordinance, ERO, I went to Section 12, and it's real short. And it's Section 12, Rule 10, Public Safety Employees. I just went on the internet, Francine. What's the difference between public safety employees and peace officers? Because under public safety employees, it has other classifications besides a peace officer. Firefighters, sewer treatment plant operators, water distribution personnel, provide services to protect the health and safety and welfare of the community.
They're sworn officers under the Peace Officers Bill of Rights. Firefighters are now under the Firefighters Bill of Rights.
And sewer plant operators are, and water distribution?
Without having what you have, I can't really answer
well,
that.
maybe Mr. Gogger can.
Or David.
Or David. I mean, all I'm saying is in their letter of appeal, they're referring to Section 12 of the Employee Relations Board Ordinance. Well, I didn't know what that was, so I looked it up. And it really...
So they're not referring to the Employer-Employee Relations Resolution, they're referring to a different document?
I just went to the internet to Employee Relations Board Ordinance Section 12. Maybe they were referring to the counties. I
don't think our employee relations resolution is on the internet. So you can't be looking at our documents, so I don't think it really
No,
matters.
I'm not. I'm looking at a state or... Okay, well, I interpreted that as not Calaveras, but state or national.
I don't know what you're
Okay,
referring
that's
to.
fine.
I'm
Never
sorry.
mind.
I'm
That's-
sorry.
that's
Without
okay.
knowing what you're referring to, I can't really answer
Okay,
your
well, that was
question.
in his letter. I didn't know what it meant. I didn't know what he's referring to, so I looked it up.
Mr. Gauger looks like he's wanting to clarify.
Please, I guess I looked at the wrong thing.
No, you didn't. You looked at the right thing. The reference to Section 12 in the letter is simply the reference to that portion of your local ordinance, the document that Mr. Beltran referred to in the acronym EERO, as the appeal section. The section that deals with peace officers and not peace officers in your local ordinance is section, there's several sections that define them. The definitions are on Section 3. Your definition of peace officer
Okay, no,
is
that's
in there, I
fine.
hope. And you also use that term of art in Section 9.
No, that's fine. You were referring to the counties. I thought it was some state or whatever.
No,
Okay, thank you.
You asked
Got it
another
covered.
question I can answer, though, that'll probably provoke agreement from all council in the room, and that is the word peace officer is a narrower group of folks than public safety officers. Public safety officers are all those folks who can't strike. Firefighters, they may or may not have peace officer status. Peace officers are people you designate as peace officers in your county. So in any particular county, your firefighter, probably not a peace officer, but your animal control officer may or may not be. Here, he's not. In other counties, they are. That's the answer to that question, which was a good question.
Thank you.
Okay, at the onset, Ms. Osborne said that there were going to be three components to this. I think we've concluded the second part, and we need comments by anyone else. So I'm opening that up at this point. Please identify yourself.
Good morning, ladies and gentlemen of the board. I'm Jeannie Middleton, Middleton. I work for the Sheriff's Department, and I'm a Sheriff Services technician. This is my life, and this is our life. This is what we do. You've probably got over 100 years, easily, of experience in county employment sitting over here. This is a fraction of the people that signed, the majority that signed the petitions over 2 years ago that said we wanted to modify. We wanted to break away and have our own unit, a public safety unit. We all work under a paramilitary organization under the Sheriff of Calaveras County. We're subject to a different standard of conduct. We're not like the road department or CalWorks or anybody else. We have internal affairs investigations where our liability is there, our confidentiality is there. And I, for one, can tell you that 20 years ago when I sat down in dispatch the first time, the conversation there then was to break away and have a separate bargaining unit that's more specialized with better representation to break away from the rest of the county. It was, at that time, was a very small amount of people. And we were a bargaining chip. There was never anything negotiated for us or specific to us. We work 24 hours a day, 7 days a week. We're on call. We're the first ones they call, and I'm speaking of also correctional officers, dispatchers, sheriff service techs, animal control, probation, district attorney. We're the first ones they call in an emergency. We're the support staff for the peace officers. This is not a new idea. 20 years ago, we wanted to break away. We asked, I'm going to guess twice, might have been 3 times, and were denied by the then CAO. We then did it again. We took a survey. Well over 2/3 of the employees involved signed the petitions wanting to break away and be modified and have this representation more specific and specialized to what we need when we're under investigation. And that happens. We support this, we've been after it, we've been on it for over 2 years. Everybody is still supportive, and as a matter of fact, due to some of the things that has happened with SEIU in the interim, we have more support now than we had in the beginning, which is great. We pray that you will look at this and understand that this is our life, this is what we do, and this is to benefit your employees. Thank you. Any questions?
Any questions of Ms. Middleton? Thank you. Anyone else wishing to comment?
Hello, ladies and gentlemen. My name's Mark Menifee, and I've been a correctional officer for the County of Calaveras now for 10 years. Mr. Beltran made the statement that this has been an ongoing issue now for 2 years, and that is a fact. We've been trying to break away for 2 years, and SEIU has been dragging their feet. I can personally tell you that SEIU's representation of correctional staff has been almost non-existent, and when it did exist, it was pathetic at best. And when we initially tried to break away, they didn't try to contact and talk to most of us at all. I have never been contacted by SEIU. Any questions?
I just have one question. You said at the onset that you're a correctional officer.
Correct.
What is your capacity? You work at the jail then? Or?
Correct.
Okay. Thank you.
Good morning, members of the board. My name is Pat Ross. I'm the Community Services Representative for the Sheriff's Department, and I have a few points I would like to make about this discussion. First of all, let's cut to the chase. All we want is the right to have an election. All of the hullabaloo for the last 2 years is because SEIU wants to stand in the way of the voting will of some of its members. If they weren't afraid they're going to lose this election, why would they be fighting so hard? They don't care whether or not you have one union or 2 unions to deal with. They don't care if there's additional expense to have to fight this. They care that they're going to lose members, dues, and power, period. Now, as it's been pointed out before, they feel that we don't have a commonality, a community of interest, which makes us a different bargaining unit. What the community of interest among this group of people is that they represent in every function that they perform, whether it's cook, whether it's community services officer, whether it's district attorney investigator, they all have the same objective, and that is to provide the public with safety from harm by people who don't play by the rules. There are other public safety officials, and some of them fall in that category because they, let's say, inspect roads or bridges, or they protect the public in other ways. This group of people either supports law enforcement officers or directly contributes to the safety of the public from harm by people that don't play by the rules. Another way we are set apart from county employees is that we have different employment procedures and qualifications. Not only do these people have to meet the basic employee standard requirements for employment with the county, they undergo a further set of requirements and regulations that has to be met, and it usually takes a period of about 6 months. There's an intense background investigation that inspects every corner of our personal and past professional lives. We're not allowed to omit anything. We are questioned on 3 or 4 different occasions. We undergo a voice stress test, which is basically a lie detector test. We have to also meet with a psychiatrist who decides just how crazy we are for winning these jobs. But our basic common bond is a dedication and an energy to this purpose of protecting the public from people who don't play by the rules. And as Jeannie said, we have a different standard of conduct. Not only are we subject to certain conduct on duty, we are also subject to rules off duty. Let me read something from the department manual to you. Or any other on-duty or off-duty conduct, which any employee knows or reasonably should know is unbecoming a member of the department, or which is contrary to good order, efficiency, or morale, or which tends to reflect unfavorably upon this department or its members. You don't want to get in a bar fight and keep your job, folks. You can do that if you work at payroll. But what I'm trying to say, and no, that is not anything disparaging against payroll. Sorry.
Everybody in payroll.
And I'm not trying to say that the people in this unit are setting themselves as superior. I'm saying that we are different. Our requirements are different. Our outlook is different. And we don't feel SEIU has represented any of that. And when I say protect people from harm by those that don't follow the rules, I personally don't want them representing me because they don't follow the rules. They have attempted to put people in our department, so to speak, undercover. People have come in there under false pretenses, sat in our dispatch department, and then started asking questions, employee questions about unions, when they were supposed to be there as observers. Now, all of us in these jobs feel very strongly about our environment and our safety in that environment. And do these people understand that? No. They've tried on a number of occasions to sneak people in there to find out what they could, and violated what I consider is the sanctity of our safety. And they're going to represent us in terms of safe working environment? I don't think so. Mark Menifee said he hadn't been contacted by SEIU reps. I put in a letter of complaint to HR because I have been contacted by them. In the run-up prior to the election, I was contacted by them 4 or 5 times. Another example of how they don't play by the rules is, where did they get my unlisted phone number? And what makes them think I'm going to respect anybody that evades my privacy by doing that? Not much. On the occasions I spoke with them when they phoned, I reiterated to them that their tactics I find extremely distasteful and unethical, and I don't feel that they are appropriate to represent this hardworking group. All we'd like from you guys is a decision that we can have an election. I think the process has become long and altered. I think SEIU has obscured a lot of water here, and we'd like your support. We're not here to get a different union bargaining unit that's going to be a pain in your keisters. We're looking for someone who understands what we need to accomplish, who actually has some experience in the field in which we work or have worked. And we want somebody who isn't willing to stoop to any level to continue to get our dues money. Thank you.
Thank you, Pat. Anyone else wishing to comment on this issue? Okay, with that, I will close the hearing and bring it back for... Oh, yes.
I don't know what the problem is, but there's a letter that I drafted last night and we prepared this morning, and I believe it's gone to you or going to you, and I don't have a copy of it yet, and I wanted to put it with the packet of things that I earlier mentioned and give it to you. So, and we expect it within 10 or 15 minutes. It's just that we have so little time. I don't have the whole thing here today, right now. So with that request, I would request that you leave the record open wide enough for me to put the letter in as soon as I receive it.
Okay, so that packet of information that you have in your hand, you're expecting to submit that one?
Yes.
Okay.
And then with the letter on top of it, and the letter didn't come in the email, we all...
Is there a whole bunch of stuff for us to read before we make a decision?
Obviously, I put it together and I wrote it, and I wouldn't want you to read it, but it's what I told you earlier today is the outline version of what I write in the letter. The letter's about 5 or 6 pages long, and it explains my arguments in more detail. It also has the evidence that supports the arguments. For instance, the Goyer letter of allegedly of the 30th, dated August 29th, was actually faxed. There's a fax line on it that says it was faxed on the 30th at 5:26. Missed it by 26 minutes. That kind of thing is in the letter, so it's a little more detailed.
I'm going to say, in the interest of being open, I mean, I don't have a problem, but I am walking out of this room at 11:30.
I hope you walk out before that.
For over 2 months. So, I mean,
this has been sitting for over 2 months?
The chair does, huh?
This has been sitting for over 2 months? I'm sorry.
I am walking out of this room at 11:30. Okay. I have a prior commitment that I've had. So if it's not here in 10 or whatever the chair would like to give, and this board doesn't take a vote, you're going to have only 3 supervisors. So I'm just going to throw that out there to make it more interesting.
I bet it's out in the parking lot as we speak. I mean, literally a few minutes at the most. But thank you very much for your courtesy.
Chairperson Thomas?
Yes.
I requested a 5-minute recess.
Let's take a 5-minute recess. Be back at 10 to 11. We'd like to reconvene. Mr. Gauger, did you get the information that you were expecting?
As promised, I did, and I'm handing it to the clerk. Well, my clerk, she asked for it.
Is it one copy, or is it a bunch of copies? Just one copy?
Yeah, Mr. Sirius's lack of dealing with us with the extension caused us to have to really hustle this morning to get even that here. If you'd like to, you can put off the vote. I'll make the appropriate number of copies and overnight it to you.
Well, we have this one.
I think we had a pretty thorough oral argument.
I do too. I do too, Mr. Chairman.
All right.
Thank you very much. Appreciate your time.
Thank you. At the onset of these proceedings, I mentioned the fact that we had nothing in front of us this morning. Mr. Sirius explained the circumstances around that, why we weren't given anything in advance, because we'd have to distribute it to everybody. I would submit to this board that I personally am not. I don't feel comfortable about making a decision on these issues today, especially that there may be other information in here that might have some relevance to this. Our county council has shown me a section in the MOU that would give us the latitude of postponing a final decision. We will not opening, or if we chose to postpone this for a week, we wouldn't be opening the public comment period or not taking any more testimony, but we would come back and render a decision next week. That's what I would feel most comfortable about doing, and I want to emphasize that I have listened to everybody's comments this morning, and I really sincerely appreciate everybody coming. But this is not a dictatorship, but I'd like to kind of pull the board here. Supervisor Tryon, do you feel compelled to make a decision on this today?
If there's no timeliness issue. Is there a timeliness issue associated?
No,
with it?
it was the resolution that's been mentioned that I was referring to. It requires that you commence to consider the matter. You've done that.
Okay.
You can take your time.
I would support a 1 or 2 week continuance.
Supervisor Toffenelli.
Not being a timeliness issue and the fact that he doesn't have everything here, I would support a 1 week. 2 weeks we don't have a meeting in 2 weeks, so it would be a 3 week.
Well, that's a wonderful time to schedule. Okay, 1 week.
You'll be down here by yourself.
No, I'm not here. I'm
Okay,
in the county.
so that's
So 1 week is fine.
1 week continuance, I would support.
Jim, why don't you hold on to that?
okay. Could I ask either of you to make a motion to that effect?
Am I chopped liver here?
No, a motion is appropriate at any time, Supervisor Callaway.
I would like to hear from Supervisor Callaway first.
I'm ready to make a decision.
Okay,
I don't think another 1 week, 2 weeks, 4 weeks is going to make any difference for the issue that is before us today.
With all due respect, somebody said that earlier this morning, but we have 3 people here that are wanting to give this one more week to sort of
Are we
spin
all
around.
here in a week? That's okay. I guess I didn't ask that
Yeah.
question.
That's 24.
Okay, everybody will be here. Otherwise, we should do it today.
Okay, did I hear a motion?
I'll move it for a 1 week continuance.
And a second?
I'll second.
Okay, moved and seconded for the final decision on this to be made by this board on the 24th of March. All in favor, say aye.
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 No, I'm a no. I'm a no.
Okay.
Is that your final decision?
Well, because the issue before us is, one, should we even be making the decision or referring it to arbitration? So that has to be...
I'm not for referring it to arbitration.
So, but that's one of the issues before us. So the question is, as Chair Thomas said, moving the decision out. What decision are we moving out? Are we moving out that it should go to arbitration or stay with the board? And then should we accept or should we reject?
Okay, why don't you pull the board on whether the board wishes to go to arbitration?
Well, I would want to...
I mean, if that's the case, then, if there's 3 votes to go to arbitration, then you don't need to move it out a week. But that's not, there's no reason to bring it back unless the board's going to make the decision. There's no reason for the board to review the packet.
Okay, I will walk out on that plank for a second. Do I hear, what are your feelings? You expressed your feelings about the arbitration. You
I
are
think,
no?
I think the Board of Supervisors should make a decision, and that's the reason I support a 1 week continuance. If the board isn't, then I don't want to have to review the whole packet and put a lot of effort in this if there's 3 votes to send it to arbitration.
Okay, Supervisor Toppinelli, how do you feel about arbitration?
I don't believe it should go to arbitration. I think we should make the decision here, whether accept it or deny the appeal.
All right, Supervisor Callaway, please.
Leave it with the Board of Supervisors.
I feel the same way. Okay, on the
Thank you for bringing the issue up, Maria.
on the motion,
pleasure.
on the motion and the second, all in favor say aye. We have 3 ayes and 1 no.
No.
Okay.
Like the men do.
For clarification, there'll be no further evidence or argument next
That's
week.
correct. That is absolutely
Just
correct.
to give the board time to read the documents and deliberate.
That's my objective. I want to give this my careful consideration.
And that's what I voted on, to give us time to review documents.
Yeah, not to reopen comments.
Okay. All right, so that concludes that item. Supervisor Callaway has, I don't know, a bus to catch or something. Are you taking Calvert Transit today?
No, the sheriff's office is going to get me to my next.
Well, I hope you don't handcuff her until she's out of the county.
Carol, Russ, on his board packet, didn't get this letter to item
Nobody
7,
did.
or did Gary, but I did. So if maybe you could get the letter attachment to them, and you might make sure Tom got it too. Thank you. I don't know why I did.
Okay, if we could keep focused here.
Make copies for everybody.
All right, the next item on the agenda is item number 9, discussion and possible action regarding the, oh, wait a minute. Could someone get Supervisor Walensky?
Have them sign in, please.
Okay, that packet of information that Mr. Goggle gave us. Carol, who has the information that Mr. Goggle submitted? Do you have it?
I sent it out to be copied for everybody.
Oh, okay, thank you. We're waiting for Supervisor Walensky to return, and then we'll come in.
Maybe that's why they call you, because they know.
We're going to item 9, Mr. Chairman.
Yes.
Where the sheriff gives us a quick rundown before he takes Marita.
Tom, could you give that to Carol? So she has
Allow me the honor, Carol.
Okay, we are on item number 9. This is discussion and possible action regarding the following. A resolution authorizing the Calaveras County Sheriff's Office to accept a grant for $164,618. That's funding to reestablish the California Multi-Jurisdictional Methamphetamine Enforcement Team. Item 2 would be a resolution authorizing changes to the position control list, and third element is to approve the budget transfer in that same amount in conjunction therewith. And this is being brought to us by Sheriff Downham.
Well, Sheriff Downham, this is the CalMet program that we had a year or so ago, and that we made the decision to eliminate last summer coming into budget because we didn't have the faith that the funding would be forthcoming from the state, and we weren't really willing to risk getting that far behind in our budget. This is a program that the critically important element in this is the drug endangered child portion of it. This grant will pay for a sheriff's sergeant, 2 deputies, an Angels Camp peace officer, and a half-time social worker. It reinstitutes a program that was very, very successful for us, and I think it's very beneficial to this community. I do want to recognize, before I shut up, the hard work that Tim Stern and Tracy Busby put into this. I mean, they have worked. The state changed their mind on this thing 10 times along the way. We dealt with numbers from 300,000 down to 60,000, and I don't know how many times they had to rewrite this to finally match up it was like the wheel was spinning and where's it going to stop? So they put a lot of work into it, a lot of effort. We are excited about getting this reestablished. And this was kind of the program that we talked about during the last budget setting, that if we could pull that money back, it would protect, through salary savings, our extra hires that we have working in the courts. So if there's any questions I can answer about this, I'd be more than happy to.
Any questions?
Yes, oh, go ahead.
No, you might get
On the funding portion, on page 8, under travel expenses, it's 0, yet aren't there costs, county cars, gas, et cetera?
I don't have a page 8, Maria.
Oh, it's
wait.
this one.
There we go.
Ray.
No, I got it.
Got it. So it doesn't show any expenses for travel, and we know that they use, county vehicles and what have you. Also, if it is for March 1 through June 30, we're only going to get paid, excuse me, on page 2, Sheriff, we're getting paid just $35,000, so we're upfronting the money, we're going to get the $35,000 just for that. In the fourth quarter, and then the rest of it will come sometime in 09-10, so that means the general fund is fronting the money and it will get reimbursed.
Yeah, it's explained in the resolution that we do. It is a billing process. So yeah,
Okay.
we will collect the money actually in the next
Okay,
budget cycle.
the other is, I know this has been a subject near and dear to Steve's heart on this, but so we have 4 months, okay? And so we go out and we do our work for 4 months, and then the grant's gone, and then we're back to no program. Is there a strategy that you or
Well, yeah, we do have a
the officers have?
We do have a strategy, and that's deciding to believe the state. This funding is guaranteed for this year and next year. If everything passes in May, then it's guaranteed for 2 additional years. It has been moved out of the state general fund, so that makes us more comfortable in believing the state will keep this commitment. It is not state general fund money. It's going to be moved out of the VLF funds.
So the monies that are being taken from social services and will be going into this, because that's what the ballot measures are in May, or for...
No, Marita, this is VLF, so I'm sure every dime we get somehow impacts everybody else, but this will be VLF funding. What will happen if those propositions don't pass, I think all these agreements are going to come off the board to decide who gets the money. But as far as this being money that social services ever would have seen, no, that's not the case.
Okay, so what it is this monies will be for this, the
164,000 is...
will be for 08-09.
Yes.
And then effective the next budget year, you will receive funding for 2 years for this program, assuming the ballot measures pass.
Yes.
Okay, thank you. That just wasn't clear to me. I appreciate it. Thank you.
Yes, Supervisor Walensky.
No questions, but I did want to make a comment. This program has had a huge effect to the improvement of my district, and there are towns that were living in a certain level of fear about activities that were happening in their midst. We had a lot of kids that were living in meth households. We had different programs working on it, but not in an integrated way. And this program really brought together the necessary resources to make a huge difference. Really appreciate the officers here and the work that they did and your leadership in this. But I would very much recommend that we do everything we can, regardless of what kind of funding comes our way, to maintain that presence in the field. I know it's not just a District 2 thing. This is a problem that is county-wide, but the costs when we don't do this are so much greater than anything, any investment we make in it, that any analysis of this would indicate the need to both resume the program and do everything we can to sustain it. I certainly would like the honor of making the motion to approve, if possible, if the questions are complete.
Okay, are there any other questions or comments?
I would like to make one small comment. Mary at CalWorks, we've talked about this, and even when our funding ran out, she saw the value in this program and kept the social worker employed with her guys, and it's been a tremendous benefit. It really has kind of pushed us in a whole new direction with this, and it's been wonderful. I think that's it.
Okay, I think motion is appropriate at this time.
All right, so moved.
I second.
I asked for additional comments in there, but the sheriff was the only one that made. Does anybody else want to make a comment on this? Okay, I hear a motion and a second. Who is the second? Okay. All in favor of the motion, say aye.
Aye.
Opposed? We have 5 for it and none against it. So congratulations, good work. Okay, moving on to item number 10, discussion and possible action regarding amendment order directing Public Works to contract with a licensed civil engineer to prepare an independent report on the integrated waste management system. And Public Works is here to give us a report.
Good morning, Mike Miller, Interim Director of Public Works. This is an item that's a follow-up to a study session from last fall when we gave you a financial picture of the long-term obligations of the integrated waste management system. You directed us to go back and do some work. We told you that we wanted to look at some efficiencies and some economies, and we wanted to look at what it would take to change the parcel fees if necessary. Immediately following that study session last fall, I assigned 2 people in our office, Kimberly Gassaway and Jonathan Mitchell, as the project leaders. I gave them full opportunity to reach anywhere into the department to get staff to assist them in an effort of trying to find a way to avert some of the financial issues we have. They've been working on this report for the last 3 or 4 months. They're both present today. And if you see me stomp my right foot twice, they'll be here to respond to your questions. This report asks simply for one thing this morning. We are asking you to approve $75,000 out of salary savings this year in the Integrated Waste Management Fund to hire a licensed civil engineer to do a Proposition 218 nexus study to look at increasing the parcel fee. Under the law, we're required when there's a what they call benefit burden to a fee that's property-based, we have to show a nexus between those fees and that property. Through our work last fall, we discovered that our nexus that we relied on actually came from Lake County, California, and was not done in Calaveras. And we felt we would be uncomfortable, and under advice of county council, it would be important to do a nexus study in Calaveras specific to our issues in this county, and that study would be more appropriate to use as a basis for future integrated waste management parcel fees. What we also are hoping to do is, if you approve this today, we will go forward and engage the engineering services to start the report. But at the same time, we have other groups that we've been working with. We're going to be meeting with the Solid Waste Task Force on March 30th. They gave us a significant list of input on long-term issues they would like us to consider in the Integrated Waste Management Fund. Both Jonathan and Kimberly have worked for the last 4 months on our 9-10 budget. Our integrated waste management budget has been reduced significantly, overall about 20%, and we've looked at efficiencies, we've looked at things that we're doing that we can do differently, and we've looked at staffing, and those things will be implemented in the 9-10 budget. All we're asking you for today is the authority to do the study. We will come back to you. When the study is complete, we will give you an overview of the entire Integrated Waste Management Fund, and then you will hold a hearing, which is called a protest hearing for Proposition 218, and the public will weigh in if they support the fee increase or not. And then lastly, we're doing a community outreach. I believe we're speaking to the Farm Bureau next week, and we're making our staff available to explain to the community, to any group that wants to have us speak to them, about what Prop 218 is and what it means to the Integrated Waste Management Fund. That's it. If you have any questions, one of us will be able to respond.
Supervisor Toffenelli.
Do you have an idea of the time frame, length of time for this Nexus study to take place?
We have a deadline in order to get it on the tax enrolled period for 10/11, and I believe the study would have to be done and complete and back to you by fall? 5 months. And then based on that time period and that protest hearing, the tax collector has said that we can meet it within the time frame to put the increase on the 2010-11 tax roll.
Any other questions?
Mr. Miller, on the 218, is it parcel owners that have the vote or voters who have the vote?
Parcel owners, the people that are affected.
So I know. I just want to clarify that for the record. So if you have 30,000 parcel owners, improved parcel owners that are now paying, or would it be all parcels improved and unimproved?
We believe that it would include unimproved if we find that there's a nexus between the services we provide. Unimproved properties can benefit from it, and I'll just give you an example. We've tried to separate yard and wood waste and some of the other diversion programs into what we call a regulatory fee and hold solid waste to the parcel tax. That's an oversimplification, but that's what we're trying for. But if we find during this Nexus study that people have undeveloped parcels and they generate waste of one sort or another that this fee pays for, then they would have a vote.
Which we know that will occur because at its past, at least, there's a lot of unimproved parcels that use the site.
Our diversion services, that's correct. But it's not just Ebbets Pass. There are other people that generate materials off their properties throughout the county. The other thing that's important to note is a protest hearing doesn't mean that every single person has to vote. They will receive a ballot in the mail, instructions and information on what to do, or they may appear here and protest. If they don't want to vote and they simply don't return the ballot, then there's a no vote count on that.
Anybody else? Supervisor Walensky.
This isn't a question, but rather a comment. There's I don't know whether it's my district or whether this is more universal, but there's a combination of sort of a confluence of issues here. One is a long memory, and more than any other issue, this particular subject seems to have resonance with my constituents, especially long-time residents. I think that combines with an economic circumstance which has become a pretty big concern, really globally, but when we look at 13.4% as the official unemployment rate in the county, if you look into some of the towns in my district, it's considerably above that. That's where we started, and things have not gotten better. So I take any effort on our part to try to fund our services as both worthwhile. That is, we need to look at the services necessary and pay for them adequately. But I weigh them against the life circumstances of my constituents. I think what that nexus requires of us is a very careful and broad view of this. I worry that if we focus overly much on the question of fees and do not, and I know that you've looked at a 20% reduction as well in the cost of this, but I do believe that we could expand the scope relative to other possible revenue sources, other approaches. My personal favorite, and one that has enormous cachet in my district, of course, is the number of people from Amador County that find ways to use our facilities for free. And since we can find, there's only one way in to the Wilseyville transfer station. They have to cross a bridge at the county line. It would be simple enough, and we've done this on spot occasions, which on a given Saturday found as many as 20 to 25 truckloads coming across. Now, some of those may be Calaveras residents or people who have dual citizenship, but clearly that stuff is not coming from or being generated from Calaveras County. And my view is they should be paying either a fee to access or paying some form of yardage or other. There are many different methods. That's a small amount, not going to solve our whole problem, but it is certainly one that has an emotional resonance in that area. I believe the same can be said of those traveling Highway 49 from Amador County going to the transfer station between Moke Hill and San Andreas. That's just one piece, but what level of cooperation we have with other counties, whether we throw our lot into a regional approach, what kinds of forms those might take, is another area that I would hope that our scope would include in the review, and I'm not sure I see that in here. I wanted to...
I'll surrender now and sit down.
Yes, of course.
Thank you, Mr. Walensky, for your question. My name is Kimberly Gasway, a business administrator in public works. I have a background in business finance. And I think that what Jonathan and I, he also has a background in engineering as well as business. And what we'd like to do is get the best return on the taxpayer's investment. I think sometimes that's been lost when we looked at this system. We were able to look quickly and see that we could find 20% cost reductions without reducing services to the community with minimal effort. And I thought oftentimes program people who we respect look to implement programs without thinking of the bigger picture costs of the people who are paying for that system. So we are very concerned about the taxpayers. We're very concerned about certain communities and their income levels and what this means to them. We also want to look at the benefit to burden, where the burden exists on the people who are actually using the system. And so the homeowners in, say, in your district aren't paying an undue share of the system compared to the trash that they're generating. The other thing for the out-of-county, there's many topics that have gotten brought up historically as part of the problem. And oftentimes when we look at that, we don't see the quantity, we don't see where the problem has been quantified. So when you talk about out-of-county waste, we looked at that briefly. We will be looking at that deeply. The engineer will be doing one part, but Jonathan and I will not be stopping our efforts at looking at the system as a whole. We did look at this. It's about 2.6% of the waste generated comes from out-of-county waste. Comes from out of the county. When you talk about a system that's already a low volume of waste, that isn't creating a dramatic problem. We can't realize economies of scale at the landfill. We have to add so many equipment operators, even with the low volume of waste that is generated. So 2% increase is not contributing a significant cost problem to the system. But if it is a problem that we want to address, we don't want to come along with a solution that's going to cost us more than the problem that we're trying to solve. And sometimes we have seen that in some of the suggested solutions. So we want to make sure we say 2.6% volume of waste represents this cost, and any solution we propose is less than that. Otherwise, we're going to cost ourselves exactly. What we are looking at is what I call, they joke with me in the department about this, what I call e-ticket items. Those are big expense items that we're looking to hit. Yard and wood waste, Marita, we were sure, Marita, that Gene Miller's doing a good job at $8 a cubic yard. That's a low cost on the volume of diverted materials. Internally, however, if we purchase a grinder, this may be a sore subject for Tom, I don't know, and it's costing us $91 an hour to operate that grinder. In addition, we are employing a full-time equipment operator. We're also employing a truck driver who is hauling that material all over this county. It's really, internally, our costs are greater than the outsourced grinding operation. So we want to look at that and say, not necessarily stop grinding internally or externally, but if they put an RFP out and find out they can get what we were doing internally for $11 a cubic yard, why are we doing it internally at $40 a cubic yard? We really shouldn't be doing it that way. The taxpayers depend on us as a department to get the best return on their investment. We don't want to double the parcel fee to homeowners when really business should be paying a greater fee. The last piece of this that we're looking at is diverted materials. The state says you have to do a good faith effort. I'm having a hard time getting someone to explain to me what that means. I said, what if we don't do a good faith effort? What happens? Typical bean counter question. And they said, well, you'll get fined so much a day. They told me the number, and I said, don't ever tell a bean counter that again. I'll pay the fine. So what you want to do is say, we want to be good stewards of the earth, do a green system. We want to get a good faith effort from the state of California, but we don't want to do it at an unreasonable cost to the citizens of the community. So what materials we select to divert to give us the best return on investment is what we're going to bring to you at the same time that the engineer is going to do the nexus study. So we're looking at reducing the cost, getting you a good return, being very conscious of the people who pay into the system, and that's the work that we've been doing. And we're going to continue that over the next year. There needs to be there's program people who are very valuable, say a diversion coordinator. She has a job to do, point of view, operations manager. We have Ray Gallagher in the audience. He is the foreman at Rock Creek, who is MOLO certified, manager of landfill operations from SWANA. He would love to bury everything. If Leslie Daniels was here, she would love to divert everything. Then you put me here. I don't care if you landfill it or divert it. Well, a little bit, but I'm going to look at the cost. So the three of us should be in partnership in that communication. Again, to consider the taxpayers, and the community also should be part of the conversation.
Might I be permitted to finish my remarks at this point?
Sure.
In relation to your response, I want to not engender a defensive reaction or one that justifies all the hard work that you've done to date. I do not denigrate that, and it is not my intent to criticize the work done to this point. What I am saying is, and I am in receipt of the Solid Waste Task Force comment that you probably received yourselves, that there are scope issues with the engineering task. We're setting forth a scope of work. This has one before us, and there are other ideas that have come in that, not in a great way, but in some significant ways, do expand what this engineering report would cover. I also, and I favor that. I favor an expansion of scope, and there are some specific areas in that communication that I'm very appreciative of and think should be added to this. The second piece of it, in my view, often not considered by people who are both interested in engineering and cost-benefit analysis, is that there's another part of the cost in relation to this. One that maybe we consider overly much in this place. But I'm not interested in provoking the entire community in relation to a solid waste fee increase on people without the full measure and full scope of this having been reviewed. And that is why I favor the scope. It has to do with our obligation to the public to recognize the current economics of it, to recognize the service requirements that we have, and to find the most efficient and effective way to do that. So in that regard, the previous speaker and I are in total agreement. In regard to the areas needed to study and what needs to be included in this engineering report, I believe that there may be some differences of opinion, which I'm not too interested in finalizing here, but would request that you go back to the Solid Waste Task Force, that you see what kind of consensus you can reach about the scope and revise it if it's appropriate. I don't believe that I'm an engineer or expert, but I believe that there are a lot of those around, and that if we have a little bit of further dialogue, we could take a week or two or three and have the kind of scope that I think our public deserves, and so that we don't have process questions or product disputes more than we're going to have anyway.
We have the former Director of Public Works, Jim Heminger, has looked at some of our work, and he's in support of what we're doing, and he'll continue to be a resource. The other thing is, what I want to assure you is this nexus study will develop the relationship between what a property should pay based on use. And as Kim said, right now, the disproportionate cost goes against the resident, and the businesses are underpaying. This nexus study will draw a better link, and will also look at the amounts that different uses generate and pay proportionately. Lastly, is we will come to you each year in advance of the budget, and we will show you the list of programs and where the economies can be made, and let you help make that decision on if we want to offer extended programs or if we want to reduce programs. One example is scrap metal. We heard for 2 years that scrap metal was making money. Well, you can get $200 a ton for it, but if you have to take it to Stockton, it's about a net of zero. Now, scrap metal, you can't give it away, but we've created this thing where people continue to want to bring it in, and we're kind of the opinion that if it's an expensive program and it's $300,000 a year and we can do some things differently and reduce the cost by 50% and still offer that program, we'll be looking at those things. The Solid Waste Task Force list is, I think, 7 pages long. They have a list of pros and cons on each thing. They have a meeting scheduled on March 30th, and both Kim and Jonathan will be at that meeting.
I think Supervisor Callaway has to leave. Is
I
that
have to
correct?
leave. I just want to say, I'm on the Solid Waste Task Force. I mean, I agree with what Steve said. What's being asked of us is to start the process, because one of the components might be, not that it would be, but might be an increase in the fee or a readjustment of the fee. And so we have to look at all components, and since we have a time frame on when we have to do that, then, I mean, I'm supporting that we do the Prop 218 required nexus study. It doesn't mean that we won't do those things that the task force has not recommended, that we don't look at that, because I think we will be looking at those things. So I just am saying, because I'm out of here.
Okay, I'll move the minute order to do the study.
Okay, there's a motion. Is there a second to the motion?
I'll second. But, I mean, Steve might want to have more to say, and maybe the public does.
Yeah, I have a couple of questions that I want to ask. Okay.
That's my opinion.
So I'm not sure procedurally how, when somebody seconds a motion, then bolts for the door.
You can open it for discussion.
Okay.
This is a nexus study that absolutely has to be made. And
Well,
all of this other discussion is appropriate, but it really isn't relevant to the agenda item before us.
Okay, but I want to express some concerns here. I too read this KRH engineering letter, and I heard you, Mr. Miller, say that Kim and Jonathan have been working on this for about 4 or 5 months. I mean, it strikes me as being peculiar that the Solid Waste Task Force hasn't been working in conjunction with their work for the last 4 or 5 months. You made reference to the fact that they did the work, and now the task force has come forward with a list of stuff. I don't know, I'm just very concerned that this may be evidence of, or it's conceivable it could be evidence of something like going out and hiring an appraiser on a piece of property and trying to influence his conclusions at the onset of the work. You're asking us to approve a $75,000 expenditure to hire an engineer, and I'm pretty much in favor of doing that, but I don't want you, I mean, it seems like to me that you also said that you're going to go out and start doing an outreach in the community and everything. It's like you're going to be attempting to justify in advance the conclusions that you hope that this engineer is going to be led to.
The engineer has nothing to do with the programs. The engineer simply develops the relationship between the waste generated by the parcel, which is the burden, and the benefit they receive and what they pay for. That's all the study does. It does not look at the programs. The staff work that's been done over the last 4 months has been going through the integrated waste management budget and gutting it to get it down to a point where there's enough money to operate till next year when this can be voted on as part of the Prop 218. No programs have been decided other than the programs that we're doing now that we have an ability to reduce the costs in. We haven't closed the door to any ideas from anybody in the community. We need the Nexus study done so we can go to the voters when we know what the cost of all the programs that you select come to and what that would mean on a parcel tax. And you could be, as we said last fall, you could pick from a menu. I could give you $2 million worth of programs a year for, and I'm making up a number, $180 per year on each parcel. You may say that's too high, and how much if we took this program out and this program out? All that's going in parallel. It's not part of the Nexus study. If we don't start the Nexus study, none of that work will even be applicable to provide programs to you because we won't be able to pay for them because we won't have a Nexus that can't be supported with fact. Without that Nexus study, we can't demonstrate that there's a relationship between everything we're doing and everything we want to do. And the law says you have to have that Nexus study.
Okay, I'm not through with my questions. The $75,000 figure, has that come about as a result of you've advertised what the scope of the work is, and somebody said I can do that for $75,000?
We called 2 engineering firms, and I think the low was 40 and the high was 100, and we picked 75. We haven't put an RFP on the street for this project.
Are you going to?
As soon as we get this approved, we will.
Okay.
I'm not familiar with the KRH letter. I don't know what that letter is you referred to.
Well, it's a member of the Solid Waste Task Force that is expressing some serious consternation about why it is that he's been on this task force and the task force has not been able to get involved in the last 4 or 5 months of deliberations on this thing.
The only thing we've done in the last 4 or 5 months is look internally at our budget and the steps legally we need to follow to address the parcel tax. We've had meetings with the former Public Works Director. We've had meetings internally with our staff. We've had operations staff, administrative staff, and diversion staff to try and find the money to continue to operate. That fund is almost broke. We've deferred closing for a year on one cell, and that's the only way we have money now to operate in this upcoming budget. That's been the focus, is to keep this thing running until we can get our ducks lined up, get this Nexus study done, and come back to you with the information from that study.
Well, there is a, I don't know, could somebody give, I can give you my copy of this, but there is it's palpable here that this person, he wants to serve this county, and he has not been given an opportunity to do so. And
May I respond? This is
certainly.
We asked staff internally to give us an opportunity first to benchmark the existing system and not to make any changes. So the first thing that we did was to take a look at the system as it is. We weren't in a place to start saying, okay, we could stop doing this. Some of the solutions became obvious quickly, but we even asked staff to hold off on any solutions. When you analyze something, you first have to say, what are you doing as a whole, and take that picture and document it. So we spent a great deal of time meeting with diversion staff, landfill operations staff. Jonathan and I went out and got down in a hole and looked at how the equipment operators were doing the garbage. So we were looking at who are the people that do the work, how do they do the work, and we've been benchmarking that work. As far as potential solutions, we're not attempting, we want to talk to everyone. We certainly do want to talk to the task force. We have internal staff who are aware of the task force, sit on the task force, and we're aware of these solutions, and they just came to us yesterday. We did not know that they had a list. We hadn't gotten to external stakeholders at this point. We were out in the field looking at the way we did it. We took a look at every truck in the metals operation, every deadhead trip. We were on the phone with the foreman. How many times do they go? How many hours do they spend doing this? I mean, that's really the work that we have been doing, in addition to talking to county council regarding the Prop 218 regulations. We welcome, I have a copy now of the task force recommendations. I got it yesterday, have already read through it. We want to go and talk to them about their ideas. I did not see the letter that you have before you. We certainly do not want to exclude anyone from the conversations, exactly the opposite. So I want to assure you that we are not making decisions to change the operations to the system without input from anyone outside. We were talking to internal existing staff first, benchmarking how do we operate this system.
Supervisor Walensky has another comment.
To some extent, I'm seeing ships passing in the night here. We have several issues. One are you've got operational efficiencies and a whole set of policy decisions that are outside the Nexus study. You also, at least in my belief, have a significant letter from a thoughtful engineer suggesting that the scope of the Nexus study could actually be broadened to good effect. And I think the question before, and we're just arguing back and forth without connection here. The real sole question before us right now is whether to do a Nexus study, and if so, what scope. I'm of the opinion that we must do a Nexus study and that we have to do it timely. But I will vote against it unless the scope is appropriate, as full as possible, so that we can explore all options for the best possible outcome. That's my position. It's not opposed to a Nexus study. It is making sure that we are not on a more narrow trajectory than we need to be. And I hope that's clear to people. If this is the document that we're voting on here, my vote will be no. If there is a document that comes back to us in a week or two with a consultation and try to reconcile the scope differences between various positions and documents, my guess is you'll have my affirmative support.
If we had a copy of the LRH letter, we'd probably be able to respond, and we would be happy to come back to you in a week and give you a follow-up to that. But I want to emphasize one thing. This is not establishing the programs. It establishes the amount of money that we're looking to charge by parcel. And it'll also determine the benefit to that parcel and apportion that cost. After that's determined and the percentages are calculated and the units of measure are agreed to, then you throw everything you want in this bowl of programs, and then you say your target is $200 a year or less per residential equivalent unit, and we tell you this program can stay in or this program can go out, and you can make those decisions. You have another year.
I don't think that this has to do with the scope. I mean, the scope, what this is going to do is establish what a residential equivalency is. And then you can decide, or the board will decide, what the scope is and what the cost of that scope is. And then you'll take a residential equivalent, or the number of residential equivalencies we have. You will divide it into whatever the cost is of the program the board adopts. and that's what the fee's going to be. So this isn't determining what the programs are.
No, absolutely not.
Or what the cost is going to be. It's just determining what a residential equivalency would be and what a residential unit would be, and then what a residential equivalency would be, so we can get the total of those units, and then whatever the programs are and the total cost, you divide that into it, and that will be the cost. And if a business is 1.5 residential,
I believe we'll be in a position to come back to the board with 5 or 6 strong candidates for each of those positions for the board to interview and make a decision. And those interviews, I will anticipate scheduling for the board during the first 2 weeks of April, first 2 weeks of March. No, April, right, I'm sorry. And we can move on from there.
Okay. Mr. Miller will continue to be serving us until that happens, or?
He's got some very specific time limitations, and he will not be exceeding them. We will go for a period where the deputy director will be running things on a day-to-day basis until the new hire takes place, but the department will continue to move forward. We're not going to have the interim director will be fading out before we have somebody on board.
Okay. When can he come, if we don't get somebody on board in a timely manner? When does the interim director able to come back and continue?
That would be July 1st, but I haven't spoken to him about that far.
When would his last day here be?
Yeah, I don't.
He told me last week yesterday it was next week is his last week. But we have his phone number.
Okay.
We can borrow it. All right, I just want to remind you that we are in recess until 1:30 when we will reconvene as the Board of Equalization, and we have a long list of things to discuss there. So.
No.